something happening here, but what it is ain't exactly clear.
The 1960s were a time when America's youth came into their own as a political generation, protesting and standing up for what they believed in. Tinker v. Des Moines was a Supreme Court case that was decided in 1969. The incident that spurred the case was the suspension of students for wearing black armbands to protest the Vietnam War in 1965.
Well, come on, all of you big strong men. Uncle Sam needs your help again. Got himself in a terrible jam way down yonder in Vietnam. Put down your books and pick up a gun. We're gonna have a whole lot of fun. And it's 1, 2, 3. What are we fighting for? Don't ask me, I don't give a damn. The next stop is Vietnam. And it's 5, 6, 7. Open up the pearly gates.
Tinker v. Des Moines fundamentally changed First Amendment rights for students. The conflict between the Tinkers' First Amendment right to protest and the school's need for order led to the compromise achieved by the court. Blackwell v. Isaquena, a case that featured African-American students wearing buttons that said freedom on them, was similar to Tinker in many ways, like how the students got suspended and went to court afterwards. In the words of Wagoner, this case, which was a precursor of Tinker in many ways, found in favor of the school district because the wearing of the buttons deteriorated the learning atmosphere of the school, creating a disruption and fistfights. It is also notable that this case took place in Mississippi and featured African-American students, whereas Tinker v. Des Moines took place in Iowa and featured white students, protesting against the Vietnam War as opposed to protesting against civil rights. Mike Heistand is an attorney at the Student Press Law Center. He also went on Tinker Tour USA with Mary Beth Tinker, teaching students across the country about their First Amendment rights.
So the question is kind of what happened in the Tinker case, and I had told Mary Beth Tinker, it seems a little bit like a Disney movie. I mean, it really is. The facts are really compelling, and it's quite a story. But Mary Beth was 13 years old. She was in junior high school in Des Moines, and she tells the story about how up until that time, she was involved in this family that was very active and socially they were very much involved in the social justice movement at the time. But she said, she was just a shy young girl that got good grades and would go roller skating on the weekends. This was outside of her wheelbox, to say the least. But she talks about how on that particular morning in December of 1965, how she used, just a little bit of courage, she said, that she had to wear this armband to school. And so she did, and she got through the first part of the day with, some of the students asking a little bit about the armband. But for the most part, she said it was fairly peaceful. Not a big deal is being made about it. But at lunch, apparently she was called down to the office and was told, Mary Beth, wearing armbands to school is against school rules. Take it off. And so she talks about, and I love this. This is almost my favorite part of the story. She said, it was at that point she realized that that little bit of courage that she had just kind of ran out, and so she said, she took the armband off, but she had done what she meant to do. There was apparently like a DJ in town, kind of a precursor to some of the shock jocks that we have today, who apparently said that if anybody was to kill Mr. Tinker, he would pay the attorney's fees.
The court ruled 7-2 in favor of the Tinkers. Abe Fortas, who wrote the majority opinion for the case, stated, "As we shall discuss, the wearing of armbands in the circumstances of this case was entirely divorced from actual or potentially disruptive conduct by those participating in it. It was closely akin to pure speech." In Justice Fortas's most memorable part of his opinion, he states, "It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate." Justice Stewart ruled with a majority on Tinker, but in his concurrence he stated, "The state may permissibly determine that, at least in some precisely delineated areas, a child, like someone in a captive audience, is not possessed of that full capacity of her individual choice, which is the presumption of First Amendment guarantees." Justice Harlan believed that students needed to prove that the rules preventing them from protesting were outside of legitimate school concerns. He stated in his dissent, "I would, in cases like this, cast upon those complaining the burden of showing that a particular school measure was motivated by other than legitimate school concerns. For example, a desire to prohibit the expression of an unpopular point of view while permitting expressions of a dominant opinion." Justice Black disagreed with the case. In his dissent wrote, "The court clearly stated that the right of free speech and assembly do not mean that everyone with opinions or beliefs to express may address a group at any public place at any time." Wagoner stated, "Based upon the Tinker decision, students are entitled to express their views in a symbolic manner most commonly addressed with messages on t-shirts or buttons, but via other forms of expression as well, including jewelry, hairstyles, rubber bracelets, tattoos, body piercings, armbands, and styles of clothing, to name just a few." Anne Millett is an attorney at the Department of Education. Here she is talking about how she interacts with Tinker and how other subsequent cases have affected it.
My name is Anne Millett, and I am a civil rights attorney at the U.S. Department of Education's Office for Civil Rights. My work at the U.S. Department of Education involves enforcing civil rights laws, and the enforcement of those laws could potentially have an impact on the First Amendment rights of students. And so it's important in my work, to be cognizant of the First Amendment rights of students, the strictures that were laid down in the holding of Tinker v. Des Moines, and cautious not to require school districts to have to take measures that would impose on the First Amendment rights of students. After the court decided Tinker in 1969, there were a progeny of cases that sort of fleshed out other areas of speech that were not protected under the First Amendment. Tinker established First Amendment protection for speech in school, that you don't drop your constitutional rights when you walk through the gates of the schoolhouse, but there are limits. In Hazelwood, the limit that was set forth was for speech that's sponsored by the school. So if the school is sponsoring speech in a newspaper, it can limit what exactly is said. In Frazier, the school said that you can't use lewd speech in school. And another example is Morse, where the student held up "Bong hits for Jesus" sign, and the court said you can't encourage drug use in your speech. That speech will not be protected. So those are other areas where the court is sort of fleshing out limitations on speech in school. I think the real impact of Tinker v. Des Moines is that it sort of marks that turning point in our country from old to modern, and the view of a preference in the 50s and previously, maybe before World War II, of a preference for order over the wild abandon of freedom and the expression of views. And in Tinker, and you see that viewpoint expressed in Black's dissent in Tinker, where he talks about children being seen and not heard. And Tinker kind of turns that and says, no, there's a value in this marketplace of ideas, and 16-year-olds and 13-year-olds and 8-year-olds, like the kids in Tinker, bring value to that expression.
In conclusion, Tinker fundamentally changed First Amendment free speech rights for students, stating that they no longer ended at the schoolhouse gates. Students have exercised this decision in a multitude of ways, and the court has further changed it with other later decisions. Ellie Vehe brought the spirit of Tinker into Shaker. Here is her talking about her actions.
Hi, I'm Ellie Vehe, and I'm a junior at Shaker Heights High School. I decided, along with a few of my teammates, that in order to protest the oppression of people of color in our country, and to make a statement and get our community involved in some of the events that are happening on a national scale, that I was going to take a knee. I was familiar with my rights before I decided to take a knee, and I emailed the ACLU to make sure that it was okay and that I wouldn't be punished for my actions in any way. And this confirmed what I already knew, and that's that I don't shed my constitutional rights when I step into the schoolhouse gates.